A warm welcome from the heart of Munich at the Data Protection Café. Today, we are discussing data protection in the application process. Data protection regulations must also be observed in the application process, especially to avoid complaints or contact with the supervisory authority. Learn more about which regulations apply in today's video. Resumes naturally contain numerous personal and sometimes confidential information, such as certificates and the like. All this information is therefore subject to the application of the GDPR. If you operate an application portal or invite applicants to submit application documents on a page on your homepage, a transparent data protection information should be linked there, informing them about the data processing procedures in the application process. The data protection information should also include a section on how they handle the data when someone submits an unsolicited application. That is, an application not directed at a specific open advertised position. For the execution of the application process, no consent is required as a legal basis. They process the data for the execution of a pre-contractual relationship. Therefore, it is also permissible under data protection law to process the data within the framework specified for the purpose. Consent is only necessary if they wish to store the data in an application pool beyond the specific application process for the specific open position. As with other data, the principle applies that applicant data may only be shared internally to the extent necessary. This means that the data must not be made publicly accessible to everyone within the company, but following the principle of necessity, it should only be made available to those individuals internally who are involved in the hiring decision. In addition, the usual technical and organizational security measures must be taken to protect the data from unauthorized access by third parties. You should also choose a procedure that technically enables the deletion of the data. So choose either a database-supported applicant platform or another in-house procedure that keeps the data stored in one place, so that the other persons who can access the data can specifically access this data to later carry out a targeted deletion of unsuccessful applications. In the job interview, it applies that questions may only be asked insofar as they directly relate to the employment relationship. In particular, searching social platforms intended for leisure activities for information about the applicant is not permissible under data protection law. Data of unsuccessful applicants must be deleted. As a general rule of thumb, the data of unsuccessful applicants should be deleted 6 months after the completion of the application process. Exception, as mentioned, they have consent to store the data longer in an application pool. The maximum time is then 3 years. To quote Giuseppe Mazzini, the secret of success lies in the will, and with that, they must transparently indicate the processing details of the application process in the data protection information. Secondly, they only need the applicant's consent if they want to store the data in an application pool beyond the application process. And the data of unsuccessful applicants must be deleted within 6 months after the completion of the application process. What else has happened in data protection? Europol has addressed government and corporate representatives in a press release warning against the widespread implementation of end-to-end encryption. Link to it in the description. Enjoy reading.